Hello. There are several questions in the community when it comes to the law, especially with immigration matters. That is why I'm inviting you to join us on the program, The Community and the Law, live on BWTV and brought to you by BWF Solicitors, our trusted partners when it comes to the law. We are going to have a very massive discussion on some of the issues of immigration matters that bother you. And they have the opportunity to meet you live on the program to explain to you all the updates that have come from the Home Office and also address your questions and concerns that you might have when it comes to the law. The Community and the Law is brought to you every Saturday between 4 p.m. and 6 p.m. UK time. We're live on all social media platforms, YouTube, Facebook, and LinkedIn, at BWF Solicitors, at BWTV, and of course, we urge you to share the program and invite others to join us. Remember, it's at 4 p.m. to 6 p.m. every Saturday, live on BWTV. You have your questions. There are answers. So join us, learn, and empower yourself on the program, The Community and the Law. So pick up the phone and dial 0208 493 7345. Or you can send a text 07950 422 780. It's The Community and the Law. My name is Oreku Frimpon and I am your host.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contested and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner, with over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Hello, good afternoon, viewers and listeners, wherever you are watching or listening to us from. This is the Community and the Law program brought to you by BWTV. Your community lawyers, BWF Solicitors, brings you another interesting conversation about EU applications for pre-settled, for settled, and all sorts. And today's conversation is going to be about applications on the basis of retention of right, what to do to avoid refusal. Before that, remember to call a friend, to tell a friend that the program is in session. Thank you for your patience. We had little technical issues, and thank you for your patience and for keeping faith. Straight into action. So we are going to do the first things first: updates, nuggets, and conversation. So for updates, we all know that the few things that the Secretary of State intends to do covers immigration application fees. And one of them is that if you are going to make your application for indefinite leave to remain for from the 8th of April 2026, remember that the fee is changing. So you have from now until 7th of April to apply. That is if you are due to apply. The fee at the moment for indefinite leave to remain is 3,029, and that is going up to 3,226 pounds. That's an increase of 197 pounds. However, there's good news. The good news is that for children applications, there's going to be a reduction. At the moment, application for children's citizenship, that's registration of a child to become a British citizen, is 1,214 pounds. And this is going down to a flat fee of £1,000. And that is good news. At least there is a drop there for us. So if you are going to apply for your child's citizenship application, good news will be that, please, the fee is going down and you are going to save a bit. So if you want to save money, wait till from April the 8th before you put in the application for the child citizenship. However, if it's your indefinite leave to remain and you are due, do it now because the fee is rather going up there. Naturalization. Again, naturalization is going to go up. So naturalization will increase by about £104, to 1,709 pounds. So that is for naturalization. So let's bear that also in mind. So, but the fee structure. So, producer, if you can share the fee structure with us. So, the fee structure, as you can see, that is the fee structure. So, the current fee for indefinite leave to remain is 3,029. From 8th of April, it's going to be 3,226. For naturalization as an adult is 1,607. It's going to go up from 8th of April to 1,709. Skilled worker visas up to 3 years as main applicant and dependent. At the moment is 304. It's going to go up to 324 pounds. Again, skilled worker health and care over 3 years. Over 3 years would be those who are on 5 years straight or 3.5 or 4 years. That is £590. £590. And again, it's going to go up to £628. £628. So, producer, move it up a bit, please. Now, visitor's visa. So visitor's visa is £127. It's changing to £135. And visitor's visa up to 2 years is £475. It's changing to £506. So these are the changes that are coming up as far as immigration fees are concerned from 8th of April 2026. Right. Now we go to the nugget. We go to the nugget. So, producer, please, let's have the nugget. But before the nugget, let's have this announcement, please. Let's have this announcement. As you are all aware, not too long ago, we lost our dear mom, the late Mrs. Helena Tutua Akiumi. Our mommy, the late Helena Tutua Akiumi, was the mother of our partner, Lawyer Eunice. Lawyer Eunice. Lawyer Eunice is a partner at BWF Solicitors. Most of you have encountered her, most of you have seen her, and most of you have enjoyed how professional she's been as far as her work is concerned. Unfortunately, she lost the mom. The funeral takes place as follows. So the funeral will be next week. Next week, Wednesday, the 25th of March, and it's going to take place in South London, Norbury. So please, those of you who can make time, join us as we celebrate the life of our Mrs. Helena Tutua Akiumi, the mother of our lawyer Eunice. Okay, right. So we move on to the next one, the nuggets. The nuggets. The nuggets. So the nugget, we have unmarried partners do not have to show that they have lived together. Unmarried partners do not have to show that they have lived together. And what it means is that following the changes to the immigration rules and on unmarried partner visas, couples may now qualify as unmarried partners even if they have not lived together for at least 2 years. Since 31st January 2024, Appendix FM requires unmarried couples to have been in a relationship similar to marriage or civil partnership for at least 2 years. The reference to living together has been removed from the rules, and therefore, if you are relying on your relationship with your partner, you do not have to show that you live together. There's no requirement for cohabitation. All you need is to show that you've been in a relationship for 2 years and the relationship is similar to that of marriage. And as far as we can, if you're able to prove that, you do not have to show that you are married. And this is from the changes that took place on the 7th of December 2023. So that is the nugget. As we always do, we bring you a teaser for you to share with us what you think about the law, about the rules. So if we have the quiz, can we have the quiz, please? Producer, can we have the quiz? All right. So we're going to have a quick commercial break. And when we return, we will bring you the quiz. Right. Quick commercial break.
Based in London, we are a dynamic award-winning firm specialising in a range of legal services. Welcome to BWF Solicitors, a trusted and experienced law firm specialising in immigration and nationality, appeals and judicial review, dispute resolution, family and matrimonial, and other family law disputes with international context. These include matters such as private child arrangement orders, contestant and uncontested divorce, non-molestation for domestic violence, and financial remedy. Our childcare and family team appreciate the issues facing you at such a difficult time. Our advice is delivered in a confidential and sensitive manner. Meet Bernard Owusu, our esteemed senior partner. With over 32 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stands for integrity, respect, excellence, teamwork, diversity, inclusion, and service to the community. We provide tailored assistance specific to your case. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Our team at BWF Solicitors is ready to assist you with all your legal needs. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Our main office line is 0208 493 7340, or our emergency line is 07712 761 884.
Okay, so welcome back from the commercial break. Lawyer Charles Asma has put us in the frame already, and things are going so smoothly. He has touched on the nugget, and I believe that we are going to test her knowledge, as he said. And the nugget talked about unmarried partners do not have to show that they have lived together. He has explained and gone on to say that following changes to the immigration rules on unmarried partner visas, couples may now qualify as unmarried partners, even if they have not lived together for the last 2 years. Since 31st of January 2024, you remember Lawyer Charles saying that, and that's also quoted from the statement of changes to the immigration rules published on the 7th of December 2023. Appendix FM requires unmarried couples to have been in a relationship similar to marriage or civil partnership for at least 2 years. The reference to living together has been dropped from the definition of an unmarried partner. So let's see if you can put your knowledge to the test now, and let's see. Selena applied for a visa to join her husband in the UK. Her husband has indefinite leave to remain in the UK. Selena's application actually was refused because the caseworker was not satisfied that the payslips provided by her husband to meet the financial requirements were genuine. Selena is appealing against the refusal. She wants to include in her evidence her husband's employment contract, a P60, and a letter from her employer to show that the payslips were issued by her husband's employer. However, she's not sure if the court will accept these pieces of evidence since they were not part of the original application supporting the various documents. Let's advise Selena. The Home Office will challenge these new evidence because Selena did not submit them originally during her visa application, as he feared. The court will reject the new evidence because the caseworker did not have the opportunity to consider them before the refusal decision. And then the third one, which is an option that we can propose to Selena, and it's that the court will accept the new evidence because they are relevant to proving whether Selena met the financial requirements or not. So think about that. We will come back to it, as Lawyer Asma mentioned earlier on. And then when you have given the answers, we will see which one would be correct and which one will be the best advice to give to Selena, person in this case study. We're going to look at EUSS right applications, retained right applications, so to speak, how to avoid refusals. So, like Charles Asma, let me come back to you quickly and ask, when we talk about retained rights in the EUSS scheme of things, what are we talking about? Sometimes we hear people say, well, I've retained my rights. Some say I've retained my rights and I can't retain my right because of X, Y, and Z. Retained right, what is it about?
Thank you. So, viewers and listeners, today's conversation, as you know, is hinged on Regulation 10 as far as EU applications or EU arrangement is concerned in the UK. Under the or within the regulations, EU nationals enter the UK. EU nationals are allowed to enter the UK with their families, or their families can join them if they are already in the UK, those nationals.
Yeah.
The nationals, as far as they remain family members of those applicants or individuals, can sponsor applications of those nationals. However, what if the nationals cease to be family members of those applicants? That is the bone of contention. What if the national ceases to be a family member? How will somebody cease to be a family member? If you marry somebody, you can cease to be a family member of that person if there is divorce. If someone gave birth to you, you cease to be a family member of that person if there's death, and so on and so forth. And so we are looking at where there is a break of relationship, or the relationship ties are severed. How will your right as a family member of an EU national be?
Okay.
So we know that within the EU provisions, especially Appendix EU to the immigration rules, there are two
Right.
sets of paragraphs that are important here. Paragraph EU 14 and a paragraph EU 11. Paragraph
Okay.
EU 14 deals with pre-settled applications, pre-settled applications, and paragraph EU 11 deals with settled applications, indefinite leave to remain for
Okay.
EU nationals. Now, those EU nationals would have already been in the UK, and so they would have already applied and been given other 5 years or indefinite leave to remain or settled status.
Okay.
And on that basis, they will sponsor their family members. You will be in a relationship, of course, whether the relationship is going on or not. Obviously, if things are not working out, you will mend it and move the relationship. However, where the family member is making an application for either pre-settled or settled status under the EU rules,
Hmm.
and the person is not able to show sponsor, what happens? If you're not able to show sponsor, it means your application cannot be taken further. However, if you're able to prove that you could not show sponsor because of factors beyond control, then you'll be pardoned. And that is Regulation 10. So, Regulation
Okay.
10 within the regulations says that where a family member has lost relationship due to supervening event, then the family member will retain the right that was already given to them. What do we mean by
Okay.
supervening events? Supervening events are events that take place by nature or that take place beyond control. So by
Hmm.
nature, we are looking at death, death,
Okay.
death. So where there's death, you have no control. So should we punish you because you have lost your partner or parent or child? That will not be fair. As a matter of
Yeah.
fact, we should rather empathize with you and support you. And so, within the wisdom of the framers of the law, they came up with a proposition that if somebody has been disadvantaged as a result of such supervening event, the person should be pardoned and their right retained.
Retained.
What right are we looking at? We are looking at a right to be able to apply to remain with your EU family member.
Okay.
So if the right to apply to remain with your EU family member has been destroyed or damaged by death or by breakdown of their marriage or
Hmm.
relationship, then you have to be pardoned as far as the rules are concerned. Hence, we have retained right of
Right.
residence. Retained
Okay.
right.
Let me get some clarification quickly here, if you don't mind. Now we're talking about supervening effects or those
Event,
situations,
event.
events. We've talked about death, which is a natural thing. But there are situations where the relationship is broken down. One partner cannot find the other. Um, can we take it on the face value to say that, well, the relationship is broken down, I have evidence of that, and I can't find the other person? So it would be a big and an influential supervening event.
If the relationship is broken down, then you have to finalize the breakdown.
Okay.
If we say finalize the breakdown, what it means is that if the relationship was as a result of marriage and the marriage is broken down, then you have to effectuate it by way of divorce.
Okay.
So where you say that your relationship is broken down, what is the supervening event? Is divorce, isn't it? And so the
Okay.
divorce, then your reason why your right has been retained. But if your relationship is broken down by separation and yet you don't have evidence of final breakdown by way of divorce, then you cannot prove that the relationship is broken down.
It's broken down. Okay. Um, well, we talked about death. We're talking about the relationship broken down and you effectuated. What other thing may be considered as a supervening event that can help one retain their right as an EE person?
As far as the rules are concerned, supervening event may occur under two limbs. Limb one is death. Limb
Mm-hmm.
two is divorce. Spouses, you can have your partner dying, or you can have the relationship itself dissolved.
Mm-hmm.
For parents, you cannot say there's a breakdown of parental relationship because it's natural, it's life. The only thing that will break that relationship with your parent is death. Is death. Again,
Okay.
so mainly is death. And if it is death, how do you prove that the person is dead? Death certificate, right?
Yes, death certificate naturally.
Exactly. And if it is divorce, you need your divorce certificate. So these are
Divorce
the
certificate.
two pieces of evidence to prove that you have encountered those supervening events and that your right must be retained for you.
But even when it comes to divorce, it goes through processes, and there are two certificates that people may get at any point in time in that process: decree nisi and the degree absolute. Uh, can either of them suffice?
Right. It's now the names have changed actually.
Oh,
The
okay.
name Yes, so the names now are conditional order to replace decree nisi and final order replacing the decree absolute. So
Okay.
another new family rules. So now yes, you need the conditional order and even that you need the final order. However, the moment you put in application for divorce
Hmm.
and the process is ongoing, you can rely on the application document to prove that the relationship is broken down
It's broken
irretrievably.
down. Okay, all right. Well, if you just joined us, we live on BWTV, and we're bringing you the community on the law this afternoon by courtesy of BWF solicitors. We're looking at EUSS retained rights applications and how to avoid refusals. Lawyer has helped us to look at two events that could give somebody the chance to argue for the retention of the right, so to speak. And we're talking about death and the end to the relationship. If it is in a marital situation, then you're looking at the divorce or the ending or whatever the situation is. You can't retrieve it, and then you would have put in a process to end it properly and legally. And if the person has passed on, you would need your death certificate as well to prove that you can retain your right. So how then do we avoid putting an application for that and getting it refused? How do we avoid that?
Right. So we gave the rules underpinning this whole process. If we
Mm-hmm.
look at Annex 1 definitions within Appendix EU to the immigration rules, Appendix 1
Mm-hmm.
defines family relationship, parent, child, and so on and so forth. So
Mhm.
if somebody is your parent or somebody is your child, then the birth certificate was there. The
Okay.
Now you are applying at the beginning, you have your birth certificate or marriage certificate, and you have evidence that this family member, the EU national, has what we call right to remain in the UK under the EUSS program. In that case, the person is what we call a qualifying sponsor or relevant sponsor. So the relevant sponsor might have already been granted 5 years or settled status indefinite under EU rules. The person is living in the UK and the person is
Mhm.
living with you. So once you make your application initially, because before you return your right, the right would have already been given to you, isn't it?
Yes.
For a right to be retained, it must
Then it
first
means that you have it already.
it must first exist. So we have to create the existence. How do you create existence of your right under EU? You create the existence if your EU family member, that is the EU national, is living in the UK, and the EU national has applied for residence in the UK, either 5 years or indefinite, living in the UK. And of course, the EU national is living with you. And the EU national has sponsored an application for you. And you have been granted that application by way of 5 years. Normally, most people will be then making application for settlement by progressing or extending from 5 years pre-settled to settled indefinite leave to remain. At that point,
Mm.
there's supervening event. At that point, what it means is that the sponsor is no longer there. And if the
Yeah.
sponsor is no longer in the picture, how do you show sponsor? Because every application, there must be a sponsor in there. And because there's no sponsor, you are going to rely on the evidence of whatever has happened to prove that, but for this, my sponsor would have been present.
Mhm.
So it's a but for test. A but for test is where you say that because of this reason, I don't have my sponsor, and so you should pardon me. And so, what do you have to show that because of this you don't have your sponsor?
Mhm.
You have to provide the death certificate or you provide the divorce certificate.
Certificate. Okay.
Now, before that, we have to look at you showing 5 years residence because for these applications, because you already have your pre-settled, you are making a settled status application. So you must show
Okay.
evidence of 5 years residence in the UK under paragraph EU 11 of the appendix EU to the immigration rules. It says
Yeah.
that an application for settled status will be considered on the basis that the applicant has been resident in the UK for 5 years prior to the time or date of the application for settled status. So we check,
Okay.
have you had 5 years residence in the UK? How do you work out the 5 years residence? If you married in the UK and at the time of your marriage you were already living in the UK with your wife or husband, then it is the date of marriage.
Okay.
We count 5 years from the date of marriage, not the date you were given the 5 years, date of marriage. Now, if it is somebody who married abroad because they were living abroad and joined their family member in the UK as a spouse, then it will be the date you entered the UK, date of entry. So you look at the visa stamp and that date of entry will be your starting point for the 5 years. Either way, you have to show that you have lived in the UK for 5 years.
For
What
five
it
years.
means
Yeah.
is if you have not lived in the UK for 5 years, because you have not from the date you entered, when we count, we don't have 5 years yet, or you haven't lived in the UK for 5 years, then we look at the fact that you have not been resident in the UK. So how will you be for 5 years? So how will you be applying for settled status? So here, let's be careful. Most people get it wrong, thinking that the
Mhm.
moment you lose your spouse or the moment you divorce, you have to make an application for indefinite. No, you make an application for indefinite when you have lived in the UK for 5 years.
For
And, that,
5 years.
and if you're already living in the UK before you made your application for 5 years, then it will be the date of marriage. If you entered the UK from abroad, it will be the date you entered. So let's take somebody who will say, okay, I've been married since let's say 2023, 2023,
Okay.
and I was granted 5 years, 2024. I divorced my wife in 2025, and I went to apply for retention of right. So I
Pension.
applied. I applied, and I've been refused in 2026. And the person wants to know whether they have a case or not. Let's do the calculation. This person married in 2023, right?
23.
So from the date of marriage, because they were already resident in the UK, if we are counting 5 years, we are not counting from the date they were granted 5 years pre-settled. We'll count from the date they were granted, they married.
They were married.
So 2023, 5 years will be what? 2028, isn't it?
2028. That's 5 years.
Good.
Yes.
Yes. And the person was granted 5 years pre-settled in 2024, which will expire in 2029.
29. Yes.
Now the person has divorced the wife or the husband in 2025, and they put in application right away for indefinite leave to remain, and they were refused in 2026. Is this
Because they haven't spent 5 years.
Very good? That is the application of the law under paragraph EU 11. You have not spent 5 years in the UK from the date of marriage. So how on earth will you be applying for
and
indefinite?
you apply for that, so that you don't qualify.
So this person would have taken advice from a pocket lawyer somewhere, and the pocket lawyer would say that, oh, if you are married, if you are divorced, then go and apply for indefinite. Forgetting that divorce alone does not give residence. Divorce only gives supervening event factor. Gives you retention of right opportunity, but it doesn't give you qualifying time to make an application for indefinite.
Okay.
So it's always important that when you are making an application for under retention of right provisions, you have to check whether you have already met the requirement for 5 years before you apply for indefinite.
Before you apply for that. Okay.
And so that is the first thing. And therefore, somebody will be refused because they didn't calculate it properly. And instead of waiting till 2028, they put in the application in 2025, thinking that because they divorced in 2025, they should be given indefinite.
Right.
So they will be refused.
So in this case, you start your counting from 2023 when you got married. Even
Yes.
though you were divorced in 2025, it does not really matter if you have evidence that you had that relationship starting in 2023. 2025, though, is broken down. You have evidence that legally you are terminating it, or you're in the process of terminating, or you have even terminated that. So when it comes to the 2028, your supervening event would kick in to say that you did not have to you lose your right. You could retain your right because you have lived in the UK for 5 years and you have supervening event into your favor. Could that be correct?
Exactly. That's the interpretation. So now let's flip it over. Let's put aside the supervening event.
Yeah.
If there's no death or divorce, will you put in the application midway, or you wait 5 years after you wait for 5 years from date of marriage?
You would have waited because that's your 5 years counting from when you had it.
Good. So if you would have waited, do you then say that because I have divorced, I'm now going to start the application even though I'm not yet 5 years from date of marriage?
It doesn't make it correct.
Exactly. That's the miscalculation that will lead to a lot of people getting refused. They jump the gun. They jump the gun, They move ahead of time. Instead of waiting till the time, people will tell them that if you are divorced or you have your family member dead, then bring the death certificate, put in application, and say that you have retained your right. But you say that you have retained your right when you are due for your indefinite. not when the event occurred.
Okay.
So let's
So
bear in
if you put in your application earlier than you're supposed to, would the caseworker rather say you do not qualify, so wait and come back, or they will blatantly refuse you?
right. So we have the rules. EU,
Hmm.
EU, paragraph EU2, paragraph EU6, all of them will tell you that you have to show that you meet the requirements in the first place for any application under EU. Whether
Hmm.
5 years or indefinite, you have to first meet the requirements. Requirement
Right.
for 5 years is that you have lived in the UK at any length, and you can get 5 years. Because you haven't lived in the UK for 5 years, they will only give you 5 years. If you have lived in the UK for 5 years, then you'll be given indefinite. So
Okay.
if you haven't lived in the UK for 5 years and you are applying for indefinite, do you meet the requirements?
No.
No. First. Now, if within those 5 years that you are waiting to apply for your indefinite, you lose your wife or husband, or you lose your mom or dad or your child, does that bring the date forward?
No.
No. So you see, this is the checklist. If no, 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 then you are not due.
Then you have to wait.
Then you have to wait till you are due. Otherwise, the caseworker will say that you applied for indefinite leave to remain, which is settled status under paragraph EU 11 of Appendix EU to the immigration rules. The EU
Hmm.
11 rules say that you should have been resident in the UK for 5 years prior to the date of your settled status application. We have checked from the date of your marriage, and we have concluded that you have not been resident in the UK for 5 years. Or we have checked from the date you entered the UK, and we conclude that you have not been resident in the UK for 5 years. Therefore, you are not due for indefinite leave to remain because you don't meet the requirement under the provisions for eligibility. Then they will move on to say that we have also considered whether we should grant you pre-settled status under EU 14. But we realize that your pre-settled status already granted will expire in 2028. Therefore, your application has been refused for settled status because you have visa to continue your life. You can move on based on what you have already.
Okay. All right. Oh well. So then, obviously, whoever would ask that question will be thinking of cost and saying that, well, if I put in that, I would have lost my money. But the presumption is that EU applications are not chargeable. That do we charge for that? Is
We
there a fee
don't.
for it?
There's no fee, but even if there is, who caused
Hmm.
the loss of financial loss? Who caused it?
Yourself, because you didn't qualify and you were jumping the gun.
So if you caused it, why should
Hmm.
we reward you for your negligence?
Hmm. Or maybe somebody was thinking that we just give you a tap at the back of your hand and listen, go back and come back.
I don't know, but when you're talking about that, whether the money will be refunded if the person were to pay
Hmm.
fees. But
Yeah.
why will your money be given to you if you decided to throw it away because you miscalculated? So you lose money if you, for example, you involved a lawyer, you still lose money
You
because
still lose money.
the legal fees. But if you involve a lawyer, no good lawyer will tell you to go ahead with the application because as part of the advice stage or process, the lawyer would have
Hmm.
told you that you don't qualify because you have not been resident in the UK for 5 years. Even though you have the
Right.
supervening event evidence, you are not due for the application because you have to wait till you have lived in the UK for 5 years. So the lawyer would have been able to prevent any potential refusal. But if it was a pocket lawyer, then the pocket lawyer wouldn't know the law to the extent that they will advise you correctly. And that's why we all have to be careful to go to the lawyers and not the half-baked lawyers.
Well, based on that and at the back of it, lawyer, let me sound this caution. I know these days we all on social media, we do live programs, we get people putting in their questions and the rest of it. Please be circumspect. People who come on social media and are worth the salt, they know what they're doing. The SRA is regulating them, or they are under the regulations and all the things that need to give them the right and the permission to advise you professionally and properly are in place. They will show you where they are, and they won't book appointments to meet you at the McDonald's restaurant. They will show where they are, and you go to meet them. But I have also realized that people are trying to impersonate some very good legal persons on social media and cloning the accounts and trying to really do the wrong things, extorting monies from people. Please be circumspect. BWF solicitors, for instance, we will tell you to come visit us. We are on the fourth floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters in North London. We work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call us on the 0208 493 7340. You can see our numbers at the bottom of the screen. Those of you in Ghana, we have an office, and if you want to patronize our services through our Ghana office, you can call 055 589 5959. And in all emergency situations, you can call us on 077 127 61884. And when we come on the program, The Community and the Law, we come off every Saturday afternoon between 4 and 6 p.m. We give you the opportunity to text us, give you the opportunity to give us a voice note or a WhatsApp message. And we also allow you to give and leave your comments in the comment section down below, either on Facebook or YouTube at BWF Solicitors and at BWTV. And you can call the studio lines 0208 493 7345. For text, WhatsApp, and voice notes 07399 208 468. It's about time I allowed you to come in with your questions and comments. Remember, I have the nugget and the quiz that will be picked up very shortly. But in the meantime, let me share my social media handles with you. And when we come back, I'll pick up your concerns. Lawyer Charles Asma is our resource person and guest this afternoon. He's a partner of BWF Solicitors. You're still live with us on BWTV, and the program is The Community and the Law, brought to you by BWF Solicitors, our trusted partners when it comes to the law. This afternoon, we're looking at retention of rights and how to avoid refusals when you put in an application for your indefinite leave to remain. We're talking EUSS situations, actually. Lawyers giving us some of the things we need to know. Before I pick up any of your questions and comments, Lawyer Asma, let me ask, what other things can lead to the applications being refused?
Right. Yes. So apart from the fact that you cannot show 5 years continuous residence in the UK, the other reason will be that you cannot prove that you have lived with your family member at a point before the event occurred. For example, you got married to your partner. You might have lived for 2 years, 3 years, or 6 months, or 1 year before the person died. So you should be able to show that you lived with the person for that period. So we have date of marriage. This is the first gap. Date of marriage to date of divorce. That's one gap.
Right.
Here, you and your partner were together, true or false?
Yeah, you are.
So can you then say that I don't have evidence for this period? No, you can't.
No,
Because you
because
were
you were
married,
married.
you married the person, you lived with the person, and you divorced the person. Let's say you married the person in
Mhm,
2020. You lived with the person, let's say you married in 2023, the example we had. You lived with the person up to 2025, 2 years, isn't it? So you
mhm,
should be able to prove that you lived together for 2 years. That's living together with the person as a family member. Either proof of address for both of you or joint and so on and so forth. That's important.
mhm,
As a matter of fact, when you were going to apply for your first 5 years, you were able to gather something to show that you were together.
mhm.
So, and that covers the first period, the initial stage of your lives. Then,
That's right.
when divorce came, from divorce going, you can't have anything to show. So, from the date of divorce, you don't have to prove anything. But before the date of divorce, you must prove something.
You will prove that you were together.
So imagine, so if you put in application and you only use the divorce certificate or the death certificate, you use your EU
Mhm,
5 years you were given. You use the ladies or the man's passport copies and so on and so forth. And you don't have any proof of address for you and for the person at the same address up to the date
mhm.
of the event, then you can't prove that there was relationship.
Right. Yeah. Yeah.
Because
It
the
makes
relationship
logical sense.
yes, because the relationship is not enough if you didn't live with a person. The relationship would have been subsisting up to the date of divorce. So
Mhm,
if you cannot prove subsisting relationship up to the date of divorce, then no. The same applies to somebody who was dependent on their family member, let's say parent, and they claim that the parent
mhm,
was looking after them. And from the date the parent died, they want to apply once they are 5 years in the UK, they want to apply for the settled status. You have to show up to the date of death, up to the date of death, that you were living with your mom or your dad or your uncle if it is under extended family provisions. But if you don't have
okay.
anything that you were living with your dad was looking after you, and so on and so forth, or your mom or whoever, then you cannot prove that there was that relationship and that you depended on the person. Because such a person will have to show dependency. And
Yeah.
dependency means that you live with a person and the person looks after you. So
After
how
you.
will you prove dependency before death if you claim you don't have anything?
Mm.
That
Yeah.
was the reason
Makes
why
sense.
the person will be refused. So
Be
evidence that
refused.
you were with the person up to the date of the event. If you don't have evidence that you were with the person up to the date of the event, the person will be refused. There are two applications that I have done which were both successful. The women, they were both women. They couldn't prove they lived with the family member, just one or two things. They couldn't prove that they lived with the family member up to the date of the event. So normally, when you put in the information of the family member, the system will check or search about their family member. If they search
Mhm,
about that family member and they're able to see that the family member has been resident in the UK for 5 years, because you are applying for indefinite, they will also check whether you have also been resident in the UK for 5 years. Then they may not come back to say, bring this or bring that. But where the EU national has not been in the UK, you may not
mhm,
even know. Because since whatever happened, well, I mean, you know how things work. Sometimes people are not careful enough to organize and keep their records or documents.
mhm,
And if you are not able to organize or keep your records and document, and you are going to apply, and the system searches the file or profile of the family member, and they are not able to confirm or prove that the family member is resident in the UK and so on and so forth, then that will go against. That is where they will say, can you bring us evidence to show that you and your family member were in a subsisting relationship up to the date of divorce or date of death?
mm, okay. Is that
And
is that where sometimes they invite people to come for interviews and the rest of it?
Again, where they are not sure, they will ask you to come for interview. And of course, if
Mm.
there is a convening event by way of death, you have to show you have your death certificate to prove that the person is not there. Or
Mm-hmm.
if it is divorce, you have your divorce certificate. So they will invite the person to both of you to come, but then you will argue that we are divorced. So how will the
Yeah.
person come with me? Then they will ask you
Mm-hmm.
to go for the interview alone. And if your answers are not consistent with the fact, they will refuse.
Okay. Well, I know people have their own questions they want to pose. So, with your permission, Lasma, I will open it up, pick up comments from the comment section from social media, other social media platforms, our WhatsApp platform, and all that. And we bring them before you to help us understand and have some answers to that. Castro Dan here more says, what are the procedures to invite my sister for a visit to the UK? I'm already in the UK and a EU resident.
Well, if you're inviting somebody to enter the UK to visit you, the person making the application as a visitor must meet the requirement under paragraph V V4.2, paragraph V4.2 of Appendix Visitors to the Immigration Rules, i.e., the person must prove that they will return. The person must prove that they will return. They will return to their country after the visit, and that the person must show that they are able to meet the cost of that trip. And again, they have to show why you will be inviting them. The key thing is returnability. If they are not able to prove that they will return to their country after the visit, they are likely to be refused. So, what does the person do that will make them want to go back? What does a person do that will prove that they are able to afford the cost? And if somebody is paying for them, why will somebody be paying for them? What is the relationship with that person? All these things are crucial. Whether the person will be granted or not depends on those factors. And if they are not able to convince the caseworker from the evidence provided in support of the application that they are genuine visitors, they will be refused.
Well, Castro, that's the answer from Lawyer Asma. We pick up the next one, which is coming from uh, Jose Tech or Jose Tech. I hope I got it right. Good evening, sir. Can someone get married with 2.5 limited leave to remain from Ghana?
Can somebody get married with 2.5 limited leave to remain?
With 2 unlimited leave to remain from Ghana.
But you see, this is the thing. This person who is holding 2.5 years limited leave to remain has actually been given that visa because they are relying on somebody. That's the whole meaning of
Okay.
2.5. Either
Mm-hmm.
they got the 2.5 because they are relying on their child, or they got the 2.5 because they are relying on a spouse.
Mm-hmm.
So if you are relying on a child, how can you bring? It says to bring who? Get married.
You marry someone.
So this person wants to bring a spouse, right?
Yeah.
How can you bring a spouse to the UK if you are not settled? You don't even know you haven't obtained what you need to be able to have a life in the UK. You are relying or depending on your child or somebody else. So you are not up there yet. How can you sponsor somebody? Somebody is sponsoring you. How can you sponsor somebody?
Okay.
However, however, if the
Mm-hmm.
question is, I have 2.5 limited leave to remain, can I bring my child? The answer is yes.
Okay.
That's the difference.
That's the difference. All right. Jose Tech, so to speak. Thank you very much. We move on to the next one. Keep them coming through. Keep them in the comment section down below or either on WhatsApp message or any of our platforms. My cousin is getting married and she wants to invite her aunties from Ghana. Please, I want to know what are the requirements needed for the invitation. I think it's kind of similar to the visa thing that you answered earlier on, isn't it, Lawyer?
Yes, it is. I mean, so for invitation, what invitation? You write a letter to say that you have a person is coming, If it is marriage, all the necessary things to go with the wedding stuff. Again, it's not about whether you are giving the person permission to come. It's whether the person will return once they have entered the UK. And what's the evidence that they will go back? So it's up to the person to prove that they will go back, not for you inviting them to prove that they will go back.
0208-493-7345. That's the telephone number. And if you want to send a text, 07399208468, or leave them in the comment section down below, either on Facebook and or YouTube at BWF Solicitors and at BWTV. I've been invited by Home Office based on my application. What are the likely questions to expect? What kind of application did you put up, Benedicta?
Exactly.
We wouldn't know.
But okay, no problem. Let's assume certain things. So let's introduce a couple of assumptions. So assumption number one: this is an application based on a child. So you have to prove that this is your child and that the child is British. At the moment, a lot of people are getting invited to attend an interview to prove that the child they are depending or relying on for the application is indeed a British child. Because the child has a British passport and the woman or the man is saying that the mother or the father was British, that's why the child became British under Section 11 of the British Nationality Act 1981. However, Home Office is now taking a view that most of those people may not necessarily be genuine parents. And so they are inviting this person who is applying based on that child to come and prove that he or she and the other parent of the child indeed met, had a baby, and they became parents. On that basis, the child became a British. So when they invite you, all they want to know is this child really the child of the British person? That is one. So when you go, prove that, yes, I met the man, we entered into relationship, we had a baby together, we didn't marry. However, he looks after his child. They have to prove all that. They will ask you questions along those lines. The next one is maybe it's a spouse visa. The person applied based on spouse, and the person has been invited to prove that it's a genuine and subsisting relationship under paragraph RWP 6.2 of appendix relationship with a partner, and also paragraph within the immigration rules, paragraph 1.6. 1.6 deals with relationship that is genuine and subsisting. Now, we explained that genuine and subsisting means that one, you are married, or if you've been in a relationship for 2 years, you are not living together, but you are in that relationship. How do you prove that? So they are inviting you to come and explain to them and convince them that yes, your relationship is one, genuine, and that the relationship is subsisting. If you are not able to prove that, then the application will be refused. If it is under EU, we've explained all that. They want you to prove that you are a family member of that EU national. And if so, why are you late with the application? If so, why didn't you provide evidence from that sponsor and all those things? So these are the three assumptions that we can introduce to answer the question because the question was not clear.
Thank you very much, lawyer, for handling it very well for us. My dear lady and friend, if you have any further detail, you can provide that. Or you can call BWF Solicitors on 0208-493-7340 to book an appointment and speak with the lawyers further on that. Well, Benedict comes in to say, my question has been answered. Thank you for participating and following. God bless. Kevin comes in, lawyer, and says, is the refusal of settled status same as retained right of the resident, or there's an application for retained right of resident? Sorry.
So Rago, that's why I said that the community, as community members, sometimes we get confused about EU application and retained right application. Retained right application is not an application per se. It's just a phraseology that you are making a return right application. It's just like somebody making a visa application under EU law and saying they're making
Mhm.
EU application. There's nothing called EU application. Every application is an application, but the law based on which you are making the application will determine the approach of the caseworker. And
So the
so
caseworker.
so most of the time we use the law to name the application. So the law is
Okay.
retention of right. So if somebody says they're making application, a retention of right application, it doesn't mean that the application is called retention of right. The application is either EU 5 years or EU indefinite. That is all we have under paragraph EU 14 for pre-settled or EU 11 for settled status. However, what is the basis of the application? One, as a partner. Two, as a parent. Three, as a
As a
partner
dependent.
or three, as a partner or parent who has retained a right
Okay.
following a supervening event.
Event. Okay. All right. Well,
So,
thank you
so
very
I
much.
think, I think
Kevin.
yeah.
Thanks
So,
for.
so Brother Cook, I think the answer to our brother is that it's all the same thing. It's all the same thing. We don't have
Okay.
separate retention application.
Separate ones for each of them is the same thing. All right. Thank you very much, lawyer, for that clarification. Kevin, thank you for your question as well. Benita, yes, I mentioned that you have acknowledged that your question has been answered. Thank you for asking and thank you for staying with us. Daniel comes in and says, can you explain to us someone who has already used the English test B1 before to apply for indefinite leave to remain? Can he or she use the English test to apply for naturalization in the future, even though the English test would have changed to B2? Once you have used it to apply or make an application, is it stuck in and it's forever, or you have to do a different test because you're going on to a different application?
Right. So, Daniel, the rule that is changing as far as English language proficiency is concerned applies to settlement application indefinite. So from
Mhm.
26th of March 2027, all those who are applying for indefinite leave to remain should present B2 and not B1. That
B1.
is that is point one. Point two, there is no mention of what you need for naturalization. Naturalization is mainly B1. If you have B2, great. Therefore, if you had B1 and used B1 for settlement, then you can use the same B1 for naturalization because nothing has changed under naturalization.
Okay. All right. Well, Daniel, thank you for your question. Thank you, lawyer, for the answer as well. We will pick up a couple of them, but remember, I'll be going back to the scenario I gave you about our dear friend Belinda and the advice we need to give her, and then we'll get lawyer to answer that. Let's pick up the next one, and it's coming from Citizen Kwejo. Iron Boy is currently on the 10-year parent route and is married to an EU national who holds pre-settled status. The marriage took place after the 31st of March 2021. Is he eligible to apply under the EU settlement scheme, or would he need to apply under the standard UK immigration rules instead?
Okay, so let's look at Iron Boy's situation. When did Iron Boy marry this person? It says
The
after
marriage took
March,
place after
after March,
31st of March 2021.
which is the same as before, which is the same as after 31st December 2020, right?
Mm-hmm.
After.
Yeah,
So
after.
the relevant date is not the date of marriage, but the date of Brexit.
Okay.
So the date of Brexit is 31st of December 2020. And so from
Mm-hmm.
1st January 2021, EU is alone, and therefore Britain is no longer part of EU. Anybody who became a family member of an EU national after that date cannot benefit from EU provisions. That's the
Okay.
law. Now let's apply the law to Iron Boy. Was Iron Boy a family member of this EU national before 1st of January 2021?
The marriage took place after 31st March.
So the question is, was Iron Boy a family member of this EU national partner before 1st of January 2021? Was he a family
No,
member before that date?
no,
No. He became after that date.
after the year.
Good. And his question is, having become a family member after that date, can I benefit from EU law? What is the answer?
No.
No. That's the answer. No.
Okay. All right, citizen. Thank you very much. Like Charles will take his time and deduce and look at the logical linkages here and there, and we can enhance our knowledge with the answers and deduce it for ourselves, maybe. Let's pick up a few more. Kwajo Tuta, or Kwajo Tufo, sorry. Great show. Watching from Hammersmith. Katie, thank you very much. Thank you very much. We appreciate your presence and participation. The next one is coming from Stephen Kufuor. Can a lady on pre-settled status make an application for her child without her husband because the husband doesn't want to add his details? Or she should wait to get her settled status and then apply for the child?
So can a lady on pre-settled status make an application for a child without the husband because the husband doesn't want to add details? Okay, so the lady pre-settled status, what is the lady's citizenship? What's the lady's nationality? Is it EU? You don't know.
No, we don't know. But
So
talking
we are
about pre-settled status, then I want to assume it's an EU dependent EU application, EUSS application, maybe.
yeah. So the person is asking, I have 5 years under EU. Can I apply for my child? Because
Mm-hmm.
my husband doesn't want to support my child's application. That's the question.
Application.
Now,
Yeah.
the lady depends on a husband, and presumption is that this lady may not be an EU national herself.
Mm-hmm.
The lady may be a family member of the husband who is himself the EU national. But then, due to the man saying that I cannot look after somebody else's child, your child also has a father. Take the child to his father to also help him or her. The husband doesn't want to help the stepchild. And this lady is asking, can I do the application for my child myself without my husband? You cannot do it without your husband because you have what you have because of your husband. So if anybody is going to apply to sponsor this child, it must be the husband who will say that I am applying for my stepchild and I'm an EU national, so I want to sponsor my child's application. But you cannot do it alone. So the best way, and the next is, should she wait to get certain status and apply for her? That is the best way. Once you have certain status, you can apply for your child. As a matter of fact, if your child was born in the UK, once you have your certain status, you can register the child to become a British citizen under Section 1, Subsection 3 of the Nationality Act of 1981, which says that if the mother or the father becomes settled after the child has been born in the UK, the child can be registered to become a British citizen.
Well, as a compliment, Kojo Tufo is saying that thank you very much for demonstrating practicality and clarity on immigration issues. Kudos. Thank you, Lawyer Charles.
Thank you.
Kevin is also expressing appreciation here, but then follows up with a question. Are GP registration for 5 years and married for 5 years and divorced after 3 years, can that grant a settled status for a non-EU family member and have evidence for living together for over 1 year?
So let's look at the reference point. Remember, when we looked at the law, we said that for anybody to be able to apply for indefinite leave to remain under EU law, they have to show that they are together or they have to show that they have retained a right due to the supervening event. Our brother is telling us that there has been divorce and so there's supervening event. Our brother also tells us that they have been married for 5 years, which means that from the date of marriage, so the marriage has survived for 5 years. The next question our brother will have to answer, because the instruction did not confirm, is that whether our brother, at the time of marriage, our brother and the wife were both resident in the UK. If they were both resident in the UK, then having been married whilst you're already in the UK for 5 years, you are due for indefinite leave to remain, settled status. So you don't have to wait for your pre-settled status date or is to be up. You can apply. However, question, what do you have to show? You have to show first that you lived with your spouse. You said that you lived with your spouse for 1 year. So you have to evidence that. And then does that mean you divorced after 1 year? It says after 3 years can grant settle. So anyway, whatever period or years you live together for, you have to evidence it. And from the date of divorce, you don't have to evidence anything. So there are two blocks. One, from the date of marriage to the date of divorce, show something that you were with your wife or husband. Then from the date of divorce up to today that you are making the application, you don't have to show anything, because in principle and logically, from date of divorce, you have nothing to do with that partner.
Well, on this note, I will pick up the nugget quickly and the case study and the case scenario.
Yeah,
and try to get the answer. Yes, lawyer.
Before the nugget comes, because the nugget was mainly about EU what was under unmarried partnership provisions.
Mm-hmm.
The quiz talks about somebody who has new evidence for appeal,
Yeah.
isn't it?
Yeah.
So we'll ask producer, if you can help us check your gadget, share with us some prompts which will serve as reference point or the basis of the law for our viewers and listeners to answer the question. So this is the basis of that. This is a reference point.
Yeah. So I'll do a quick read of that. The Immigration Asylum Tribunal may consider any relevant evidence to the substance of the refusal decision, including matter or evidence arising after the decision was made. However, the tribunal cannot consider new matters without the Secretary of State's consent. A new matter is defined as a ground of appeal that has not previously been considered by the Secretary of State in the context of the original refusal decision. This one from Section 85 of the Nationality, Immigration and Asylum Act of 2002, Rule 14.2b, First Year Tribunal Procedure Rules of 2014. So let's go to our friend, our lady's situation who wanted to provide some new evidence. Can we have that one and get your answers as well? Selena is the person we're talking about here. She applied for a visa to join her husband in the UK. Her husband has indefinite leave to remain in the UK. Selena's application was refused because the caseworker was not satisfied that the pay slips provided by her husband to meet the financial requirements were genuine. She's appealing against the refusal. She wants to include in her evidence her husband's employment contract, a P60, a letter from her employer to show that the pay slips were issued by her husband's employer. However, she's not sure that the court will accept these new pieces of evidence since they were not part of the original application. So help me advise her. I've got three options here. Which one would be the most appropriate advice to give her? The Home Office will challenge these new evidences or new pieces of evidence because Selena did not submit them originally during her visa application. The court will reject the new evidence because the caseworker did not have the opportunity to consider them before the refusal decision. Or then the third one would be the court will accept the new evidence because they are relevant to proving whether Selena met the financial requirements or not. Quickly, let me see what answers you have for me. Let's put them on. Here, if you have started answering, I know you have been considering that. We're testing our knowledge of the law. Lawyer Asma will help us to really put up what or consider the correct one. Bethany Daniels says number 2, the court will reject the new evidence because the caseworker did not have the chance to look at them. Thank you, Bethany. Next one, we have an answer from Kweku Dankwa, thinks it's number 3. The court will allow it. Okay, thank you, Kweku. Let's go to the next answer. Quickly, I'll take about just a 2 or 3 more. Then I'll get lawyer to answer that. Atokwame says it's number 3. Yes, the law at the court will allow that. Citizen Kojo say number 3. Kofi MP says number 2. And then the final one, let's see, Citizen Kojo says number 2. Lawyer, what would be the best one?
Right. So let's go back to the reference point, the law.
Okay.
So, Bragoku, the whole thing is to apply the law to the facts. And that is what the judges do. What does the law say? What is the situation? And juxtaposing the two, what is the conclusion? So what does the law say?
The Immigration Asylum Tribunal may consider any relevant evidence to the substance of the refusal decision, including a matter of evidence arising after the decision was made. However, the tribunal cannot consider new matters without the Secretary of State's consent. A new matter, as defined in the law, is a ground of appeal that has not previously been considered by the Secretary of State in the context of the original refusal decision, lawyer.
So stay there. Leave the law. Leave the law because we have the fact. Our sister applied for visa. Our sister was refused. The caseworker said that, well, what you brought is not enough to prove that there is financial requirement met, or there is the financial requirement is met. Then the case goes to court because our sister was given right of appeal. Then during the appeal case building or the evidence building stage, our sister's husband was able to provide enough evidence from the employers to confirm that indeed he's still working with the employer, he meets the requirement, and that the application should have been granted. Our sister is not sure whether this new evidence or this new information can be used. Let's see whether this is a new matter. A new matter is defined as a matter that is not previously considered, isn't it?
Mm-hmm.
The point before us is, does this person work? Does this person earn money? And is this money enough for visa purposes? That is the basis of the refusal, isn't it?
Mm-hmm.
And that cannot
so
be
if
a
I
new
can
matter.
prove it.
That
So
cannot be a new
there's
matter.
no
That is the existing matter.
Mm-hmm.
That is the issue for determination before the court, whether the person meets the requirement or not. The information the person is now providing, is this proving the same matter or a new matter?
It's the same matter.
The same matter, and therefore this is not a new matter where the Secretary of State must give permission.
Mm-hmm.
And so we don't need permission from the Secretary of State. Our sister would then gather all this evidence to prove that, look, this is the employer's letter, even though it wasn't there before, this is this, and my husband meets the requirement, and so I should be granted the visa as a spouse of a qualifying partner. And that is the contention.
Mm-hmm.
And with this, the court must agree. And please go to the law again. Back to the law. So under the Section 85 of the Nationality, Immigration and Asylum Act 2002, and also the First Year Tribunal Procedure Rules, Rule 14(2)b, it says that if the matter is not new and the evidence goes to support the claim of the applicant, then the evidence must be accepted by the court. And so it must be accepted. The answer is 3.
So those of you that chose number 3, the answer is the most appropriate we can give to Selina. The court will accept the new evidence because they are relevant to proving whether Selina met the financial requirement or not. Thank you very much, Lawyer Charles Asma, for helping us look at that. This afternoon, we've looked at a very interesting topic. You may think that is quite straightforward, but there are several things you need to really consider before you can get your retained right application not refused. Lawyer, 1 minute. Is that the correct summary of what we have talked about?
Yes, that is the position of law. Retention of right is not a separate application. It's an application, it's a basis of an application for indefinite leave to remain within the EU rules. To show that, you have to prove that you lived with that person before they died or before the marriage ended. And from the date of divorce or death, there's no evidence again. However, if you're not able to prove that you were 5 years in the UK before you made that application, the application will be refused because you have to meet EU 11, which talks about 5 years before being granted indefinite. And you also have to show that you lived with a person before that incident occurred, death or divorce. If you don't have evidence, it will also be difficult for you to be granted the visa. These are the basis on which an application to remain in the UK for indefinite leave to remain under based on your retention of right could be refused and what you can do to avoid. Thank you.
Thank you very much, Layasma, and we will have the opportunity of meeting you again same time. But for the rest of the period, I've got a few announcements I want to quickly go through to. First of all, we have some appreciations coming from clients and the community that we want to quickly look at. And then the announcement, remember, we have our bereavement and the funeral is coming up. I'll be giving you details of that. And maybe quickly look at our nugget again, which one talks about married partners do not have to show that they have lived together. Following changes to the immigration rules on a married partner visas, couples may now qualify as married partners even if they have not lived together for the last 2 years. Since the 31st of January 2024, to have relationships similar to marriage or civil partnership for at least 2 years. The reference to living together has been dropped from the definition of an unmarried partner, and this one is from the statement of changes to the immigration rules published on the 7th of December 2023. Well, other updates we have is on the immigration fees, and they are going up from the 8th of February 2026. But remember, child citizenship registration fees are rather coming down. So we've got 4 quick points here. The indefinite leave to remain is going up by £197 to £3,226. If you're going for naturalization, from the 8th of April 2026, it will increase by £104 to £1,709. The British citizenship allowance is dropping for children, is dropping from 1,214 to £1,000. Then finally, a indefinite leave to remain or enter from £3,029, it's going to £3,226. All applications made before the 8th of February 2026 shall attract the old fees. So, as we often say, the earlier the better. If you have anything, do it before the 8th of April. On Wednesday, the 25th of March 2025, at 10 a.m., we're going to have the funeral service of our late mom, Mrs. Helena Tutu Akumi. Mrs. Helena Tutu Akumi was the mother of a partner, lawyer EUSS Champon. The burial service, or the funeral service, so to speak, would take place at Trinity Baptist Church, West Norwood. We're going to go in black. The body will be laid to rest on the same Wednesday at 2 p.m. prompt at the Croydon Cemetery, Mitcham Road in Croydon. Then we'll do a reception from 3 p.m. to 6 p.m. at the Trinity Baptist Church, same day. And then finally, we'll have a Thanksgiving service next week, Sunday, at the Barking Baptist Church in East London. Please take note. If you want further details, you can call the office 0208 493 7340 and it will give you further details. Let's go and mourn with our lawyer Eunice, as she has lost her dear mum. Our souls, our condolences go to her and the rest of the family. May God grant her the courage to go through this very difficult period. Well, so to the rest of you out there, I want to say thank you so very much for bearing with us. We had a few hitches from the beginning, so couldn't start on time, but yeah, better late than never. We have had a very fruitful discussion. We have looked at how to avoid refusal when we putting in an application as retaining our rights in EUSS applications. Lawyer Charles Asma was our resource person and guest. We want to say thank you to BWF Solicitors for allowing us to do this every Saturday. It's the community and the law, and we come your way between 4 and 6 p.m. live on BWTV. I worked with Shilankra and Padmo Dodu, and my studio producer was Professor Ade. My name is Oriku Frimpon. Have a good evening.
From London to Ghana, yeah. BWF in the house, let's go. Integrity, excellence, we rise together. We stand with you. We stand with you. BWF, when the path is tough, we'll pull you through. From Seven Sisters to Accra too. We stand with you. We stand with you. On the high road in London town, 28 on a house we're found. And Christine the sound. Family, immigration, wills and probate, we're around. 30 years strong in the game. We got a law in our name. When life gets heavy, we lift the weight. Together we claim the fame. Oh, you want a dream? You need a team. BBUF by your side, shine like the stream. From across Golden Dawn to London.